We will get analysis on the Enyobeni Tavern case with legal analyst Mpumelelo Zikalala later on in the program. Well, the ANC Secretary-General Fikile Mbalula says that the party has resolved that South Africa should pull out of the Rome Statute. This after the court issued a warrant of arrest against Russian President Vladimir Putin for alleged war crimes relating to the unlawful deportation of children from Ukraine to Russia. For more analysis, we are now joined by the director of the UJ Center for Africa-China Study, Professor David Monyae. Prof, a pleasure to have you on the show as always.
Good evening.
Let's start here. I mean, is it safe to say that, these warrants of arrests that are issued by the ICC are, causing diplomatic problems for South Africa?
No, indeed. I think we've been here before in the past, and it's unfortunate that the ANC and the government has been forced to take this drastic measure to protect South Africa's interests and South Africa's foreign policy. That these institutions are very important. ICC is very important. And there's a strong belief within the ANC itself and ANC in government that South Africa should play a critical role as part of a member of international community to strengthen these institutions for global good governance.
Yeah.
However, I think time and again it has been proven that these institutions are somehow captured by the developed countries to advance their own interests at the expense of developing countries such as South Africa. And the ICC is a case in point.
Yeah.
That in the past it has had a number of top leaders in the US and Britain and everywhere who have committed atrocities and nothing was done, and it appears as if there's nothing going on.
When a country signs to be a signatory to a particular statute, one would assume that there are pros and cons. We're now talking about those cons. But what exactly were the pros of being a signatory to that Rome Statute, which obviously then created this International Criminal Court, and now we find ourselves where we were? What was great about signing it back then? Because it seems as though it's becoming more burdensome than it actually is beneficial to South Africa.
I think there are so many. I think to start with, I think what made this case quite unique is that not only did South Africa sign, I think what brought the danger in terms of undermining its strategic objective in terms of relation with BRIC members and other important actors in advancing its national interests. The government was caught up in that kind of situation. I think what the government did was to domesticate the treaty itself. What it means is that the treaty is part of South Africa's domestic laws, and therefore I think to extricate itself from this kind of situation is to pull out and ensure that it's done in a legal way, following the right processes, going to Parliament, given the division of labor, the executive, the Parliament, and other important bodies that are supposed to play a critical role.
And I mean, on that note, in terms of the withdrawal of South Africa, what exactly needs to then happen? I mean, you're touching on it briefly there. What is that process that, South Africa as a country would have to go through for it to remove itself, as a signatory to this particular statute? I mean, back in 2017, the High Court had ruled that the withdrawing of being a signatory to the Rome Statute would be unconstitutional. And I hear you saying, it also forms part of domestic law. So what are the prospects of success then for South Africa when we're talking about actually removing oneself as a signatory then?
I think what's critical is the Parliament, and I think the country's constitution is quite clear. Should it go through the process in Parliament in terms of withdrawal, no any other party could play, as long as the process is done legally and in a proper way, and therefore justice as a function ministry will play a critical role in terms of preparing relevant documents that has to be submitted for South Africa's withdrawal. It's sensitive matter. It has to be done following all procedure in the right way. But the political decision has been taken. There might be challenges here and there, but if the head of state states and the governing party endorse the fact that South Africa has to pull out, I think that's the position that will be taken.
Yeah, I raised the issue of, the burdensome role that is placed on nations that are signatories. And, I want to reflect on this issue of these ICC or warrants of arrest and why a particular burden is then placed on the signatories and not on the ICC itself, because one would imagine that even the International Criminal Court understands the sort of pressure, diplomatic problems that a nation would be really putting itself in the middle of should they arrest, let's say, the leader or president of another country in their own nation. And in fact, I think I heard the Secretary-General of the ANC talking about the fact that, no head of state can be arrested in another country. I'm not sure which legislation was backing him in that, but I assume he was talking about a specific piece of legislation that backs him.
I think from a political standpoint, it is quite difficult and in diplomacy really to arrest a sitting head of state. And given South Africa's position, and we're not talking about any other ordinary head of state, we're talking of head of state of a country that has plus minus 1,600 nuclear weapons. And that state has made it quite clear that anyone arresting its head of state, it's a declaration of war. And I don't think South Africa has the capacity to start with to arrest President Putin. Also, its own standing on the African continent. South Africa played a critical role in bringing in a number of African countries into ICC, and has been a champion since 1994, South Africa's foreign policy, pro-human rights, and the need to have the rule of law, not domestically, but internationally. It's critical. I think it remains an objective of the ANC government. However, the manner in which this matter has been handled, setting up South Africa, handling it in a way at the time when South Africa is hosting a BRICS summit and try to arrest President Putin. It was done in bad faith. It was a wrong move by the ICC judges. And they knew that South Africa doesn't have the capacity to do so, other than the desire to disrupt the BRICS summit. I think that one would read as the main objective of those who made this particular decision.
Prof. Monyae, always a pleasure. Thank you very much for your input. We certainly do appreciate your time. That's Professor David Monyae, who is the director of the University of Johannesburg Center for Africa-China Studies.